last year to transition to KIR. Now I act as the executive director. I'm really excited to give this presentation today, and let's see. This is the first time I've used present on Teams, so I guess the arrow key doesn't work. A few housekeeping notes of my own, that this presentation is for informational, educational purposes only. It does not constitute legal advice. And this is very important, and I'll harp on this a few times during this presentation, that all situations are different when it comes to legal issues, when it comes to relationships, contract relationships, and if there's ever any question, to reach out to specific attorneys uh, who who specialize in Medicaid fraud or Medicaid regulations. Yeah, don't go to an ambulance chaser and ask them about whether or not they know what the Eliminating Kickbacks and Recovery Act is. You won't get a good answer. So for those who are unaware of the Eliminating Kickbacks and Recovery Act, it was one of the over 120 laws that were passed in the Support Act passed in 2018 in response to the opioid crisis. That's the Substance Use Disorder Prevention that Promotes Opioid Recovery and Treatment for Patients and Communities Act. The government loves their acronyms, so that's the Support Act. That actually was refunded this year, specifically with regards to recovery housing. Something we're really excited about are the RHP, the Recovery Housing Program that goes down. I know in Kentucky it goes through our Department of Local Government. For each state, it's a little bit different, but we're really excited to have heard that that little piece got refunded for the next couple of years. Included in the Support Act is the Eliminating Kickbacks and Recovery Act, with the congressional intent behind it to prohibit individuals from referring substance use patients in exchange for kickbacks to recovery homes, clinical treatment facilities, and laboratories. What Congress was seeing, or we're getting complaints about, were clinical treatment providers essentially hiring headhunters, having people who would go to different communities and then find vulnerable individuals and then ship them across the country or ship them to a treatment provider who would then bill the heck out of their insurance for services. And these headhunters were getting paid upwards of $5,000 to $10,000 a head. It was promoting fraud and abuse in the industry. And Senator Marco Rubio out of Florida was one of the sponsors of this bill. Now, one of the issues that came from its inclusion is it was a last minute addition to the Support Act. And as such, it didn't go through a very lengthy vetting process. Like for example, here in Kentucky, our legislative session is January through April. Now, right now, certain reps and senators are bringing to different committees bills that they are proposing to get feedback on, to vet them, to see whether or not there may be unintended consequences or if there's ways they could write it better. That's the typical legislative vetting process. We've transitioned, like we as a country has transitioned a little bit further away from that with a lot of kind of ad hoc legislation that is coming through, and this is one of those issues where it didn't get much vetting prior to its passing. And for those, this is the actual verbiage of EKRA itself, which is the Eliminating Kickbacks and Recovery Act. And you can find that in 18 United States Code Section 220, which is listed as offense, except as provided in subsection B. And I'll get into subsection B later. You're going to see it a lot. It's 8 statutory exceptions to this that won't be considered violations of EKRA. However, with respect to services covered by a healthcare benefit program in or affecting interstate or foreign commerce, knowingly and willingly solicits or receives any remuneration, including any kickback, bribe, or rebate, directly or indirectly, overtly or covertly, in cash or in kind, in return for referring a patient or patronage to a recovery home, clinical treatment facility, or laboratory, or pays or offers any remuneration, including kickback, bribe, or rebate, directly or indirectly, overtly or covertly, in cash or in kind, to induce a referral of an individual to a recovery home, clinical treatment facility, or laboratory, or in exchange for an individual using the services of that recovery home, treatment facility, or lab, shall be fined not more than 200,000, imprisoned not more than 10 years, or both for each occurrence. Now, as this includes prison time, that's the telltale. It is a criminal statute, and that will go back to the knowingly and willfully, which I'll discuss in a little bit. Now, to best understand this, we're going to go line by line on this statute. I'm going to talk about the individual words that are utilized and how they have been interpreted in different judicial opinions to give everyone a better idea of exactly what they mean when you read this, because there's a lot of stuff here, and like, what does knowingly and willfully mean? What is remuneration? How are these different entities defined? So we'll get into each one in detail. So first, when is EKRA triggered? Now, it's specifically services covered by a healthcare benefit program. Now, this is one of the definitions that is actually included in the statute. So that one we don't have to wait for a judicial opinion about, and that is actually defined as any public or private plan or contract affecting commerce under which any medical benefit, item, or service is provided to an individual and includes any individual or entity who is providing a medical benefit, item, or service for which payment may be made under the plan or contract. Now, this means that it is an all-payer statute, meaning it doesn't matter if it's Medicaid, Medicare, TRICARE, or federal, like a plan that's off the federal marketplace, or private insurance. It is an all-payer statute. And that's where the expanded scope from the anti-kickback statute comes in. That is something that I'll talk about after going through EKRA, is the anti-kickback statute and how it applies to EKRA and how this was a transition from the anti-kickback statute. Now, immediately we can see some issues with this. Historically, private insurance was governed by state law. The anti-kickback statute was passed decades ago. It was like 1972 that it was passed. So, and that specifically is related to federally funded healthcare programs. So, private insurance was essentially the domain of state governments. So many state governments enacted laws around private insurance. So there may be conflict. That was another issue that, could have been vetted out in the legislation process, but was not. Who does EKRA apply to? As it states in the statute, solicits or receives any remuneration in exchange, let's see, for referring a patient or patrons to a recovery home, clinical treatment facility, or laboratory. A recovery home is another one that is defined in statute, and the term recovery home means a shared living environment that is or purports to be free from alcohol or illicit drug use and centered upon peer support and connection to services that promote sustained recovery from substance use disorder. This is where our certified recovery homes fall under. Now, something interesting here is, where it includes or purports to be free from alcohol. So, for those familiar with fair housing, another federal law, individuals in recovery are protected under fair housing, but only if they're abstaining from the use of narcotics. So, a house that is claiming to be a sober living house, but allows all the residents to use drugs and drink, would not have fair housing protections. So it's just kind of interesting how where they kind of preempted that with this statute and this definition. Clinical treatment facility is defined in statute as a medical setting other than a hospital that provides detoxification, risk reduction, outpatient treatment and care, residential treatment, or rehabilitation for substance use pursuant to licensure or certification under state law. So it's a fairly wide scope of entities. So not your giant hospital down the street, but more your rehab, your outpatient provider, laboratory, excuse me, that will be defined later, but your different clinical treatment facilities. And then laboratory. The term laboratory or clinical laboratory means any facility for the biological, microbiological, serological, chemical, hematological. I'm not going to be able to pronounce a lot of these words. I apologize. I'm a recovery housing operator and not a scientist. Essentially, what this is saying is that not just drug toxicology labs are covered by this, but any and all laboratories, whatever types of testing they do, are covered by this statute, and services would be triggered by EKRA. And solicits or receives any remuneration, including any kickback, bribe, or rebate. So what has to be exchanged here is defined in statutes of remuneration, which the term remuneration includes the waiver of coinsurance and deductible amounts or any part thereof, and transfers of items or services for free or other than fair market value. Now, fair market value itself is a fairly loaded term because what really is fair market value, and especially when it comes uh, to our guys' business, like recovery homes, there's fair market value for the lease of a house, but what is the lease of a shared room? What is the fair market value of having 8 people in a 4-bedroom house that has 2 bathrooms? Like, what is that fair market value? There can be some evidence to show what it is, but it is another. It's a term that ends up being decided by the totality of the circumstances. But as you can see, remuneration itself can be defined very broadly to anything, and um, where it impacts recovery housing is generally along the lines of free or reduced rent, or in some cases, payments directly made to recovery housing operators to refer their residents to specific clinical providers or laboratories. And how can these payments be made? Directly, indirectly, overtly, or covertly, in cash or in kind. This is an extremely wide scope, and directly or indirectly is actually it's broadly interpreted. That is recognized case law regarding how directly or indirectly can be interpreted. Many of the cases around ECRA involve marketing firms. They involve middlemen between either labs and customers or doctors, and so there's a field of law around what does indirectly look like when there's a middleman that is not influencing specific decisions. So they interpret indirectly broadly so that there can be liability. Overtly or covertly, that can include a formal contract or under the table payments. It does not necessarily need to be a formal agreement or a dead drop with $20,000 in it. In cash or in kind, not relegated to cash payments, but anything of value meeting the definition of remuneration. I've seen examples of vacations being used, of cars. It's an illegal example, but in Florida, there was an example of drugs being used to induce individuals to receive services from a specific provider. And then in return for referring a patient or patronage to a recovery home, treatment facility, or laboratory. Referral is not defined statutorily in ECRA. And that does create its own issue because what does it actually mean to refer someone to a specific set of care or a specific clinical provider? If you are, for example, if someone is living in your recovery residence and your recovery residence requires someone follow a treatment plan and they go to a clinical provider that you happen to get a payment from, is that you referring that individual or is that them choosing it? It will end up going back to the totality of the circumstances, determine what sort of influence was there, like what was apparent to influence that decision. And to induce a referral. So this is not just a referral itself where someone has actually referred someone to a recovery house, a lab, or a clinical provider, but to induce a referral. Now, inducement itself has actually been very very recently defined by the Ninth Circuit, so one that actually impacts you guys out there in Washington, is that induce a referral by paying someone who could in turn affect a referral, even if the person who received the payment did not himself have the ability to order a laboratory test or refer a patient to a treatment facility, we can add in, or a recovery residence, that the statutory language applies to anyone who pays remuneration directly or indirectly to induce a referral further supports this reading, and that's in the United States for Sheena. Um, and this involved a lab company that was using a marketing agent to induce referrals from specific doctors. Um, Now, when looking at inducement, courts have to recognize that EKRA is itself a criminal statute, and induce does have a specialized meaning historically in criminal law, and it means encouragement. Mere encouragement would not violate the statute. The facts must evidence undue influence. It must evidence that either what they knew they were doing was wrong, or there was some sort of influence they had that goes beyond just, hey, this is a good thing to do. An example on this is one that you would not find undue influence, as specifically evidenced by the court, is a lab that paid individuals to go bring business cards to different doctors' offices and drop them off. And then those cards were numbered, and if there was referrals based on those numbers, the people who dropped them off, they got a certain they got a certain bonus based on the referrals. Court found that there was not undue influence there because the salespeople didn't have any interactions with the doctors and could not influence their decisions, despite the fact that they had referral-based bonuses. Now, in Sheena, the court found undue influence where marketers were paid a percentage of lab test billings and used misleading information to persuade doctors to order those tests. In this specific case, this was actually during COVID, and this was a lab company that primarily did allergy testing and then started doing blood COVID testing during COVID and had its salespeople or marketing people telling doctors that their blood test was more accurate than the nationally recognized the nose swab test. And so the court did find that there was undue influence in that scenario. And then in exchange for an individual using the services of that recovery home, clinical treatment facility, or laboratory. So the initial slide, the previous slide, is about inducing a referral, and this is directly in exchange, where this person wants to, I want this person to go to XYZ IOP provider. I'll pay them $100 for each class that they attend over there, for example. Essentially a quid pro quo arrangement. And then a question that I like to bring up is this is regarding recovery homes as well. However, you know, while we would all like it to be, recovery housing itself is not typically a billable service. It's definitely not a billable service through Medicaid. There's a couple pilot programs out there. Um, but it would be difficult to demonstrate a kickback for a recovery residence when there's no actual billable service involved, since that would predicate the statute as needing to be about billable services. And then knowingly and willingly, and this goes back to it being a criminal statute, which requires mens rea. It's the intent that while this has not yet been interpreted with regards to EKRA, there's a semi-recent Second Circuit Court opinion that states that for the purposes of the anti-kickback statute, which is not EKRA, but courts with regards to EKRA utilize um, judicial interpretation regarding certain sections of the anti-kickback statute to kind of assist them in their own opinions. But for the purposes of the AKS, knowing and willfully means the person intentionally does act, so intentionally either solicited or received or paid remuneration, and then knows what they are doing is against the law, even if they don't know they're violating a specific law. Now, and that itself, the knows what they're doing is against the law, that can be shown in several different ways when it comes to criminal intent. That could be shown via actual awareness, um, reckless disregard for the truth. So that's um, us as recovery housing operators not looking into laws or, for example, attending this presentation and then not listening to it and specifically doing the exact opposite could show could be an example of reckless disregard. It would be shown by the totality of the circumstances to demonstrate that an individual should have had knowledge, either had knowledge or should have had knowledge that their actions were illegal, or were in violation of a law that it was associated with their business, such that they would be fined to have knowledge or be acting knowingly and willingly. And then penalties. Um, shall be fined not more than 200,000, imprisoned not more than 10 years, or both for each occurrence. And this is for each occurrence. So uh, this could be, millions of dollars of fines for an individual who was under investigation for several years. Could be many years in prison as well. Generally, Department of Justice likes to settle things, but this can be, for each occurrence, can be a huge, huge fine. And then there's potential ancillary consequences for violations of EKRA, which could be licensure revocation or suspension or sanction. You could also be prohibited from, if you're a clinical provider, prohibited from being approved for like billing insurance, being approved to bill government or private healthcare programs. Pardon me. And then exceptions. So this goes back to subsection 2 that I mentioned earlier regarding what may not, what is not covered by EKRA. Here are situations where the totality of the circumstances or the statutory exceptions for certain actions and contracts that would not be a violation of EKRA. First one being a discount or other reduction in price obtained by a provider of services or any other entity under a healthcare benefit program if the reduction in price is properly disclosed and appropriately reflected in the cost claimed or charges made by the provider or entity. An example of this could be, and again, always reach out to an attorney about any specific situations, but a lab company stating they will do 20% off their billing for all recovery homes nationwide. And they advertise that, and that discount is reflected, and when they bill insurance, that is something that is potentially okay under this exception. Payments made by an employer to an employee or independent contractor who has a bona fide employment or contractual relationship with such employer for employment if the employee's payment is not determined by or does not vary by the number of individuals referred to a particular home, treatment facility, or lab, a number of tests or procedures performed, the amount billed to or received from, in part or in whole, the healthcare benefit program. So essentially, see, there's a bona fide employee safe harbor where an outreach worker who is paid, where their job is specifically to go out and try to convince people to go to a certain provider, as long as their payments aren't predicated on increased referrals. And a discount, further exceptions. There's 7 statutory exceptions, and then an 8th, which regards regulations. The third is a discount in the price of an applicable drug of a manufacturer that is furnished to an applicable beneficiary under the Medicare Coverage Gap Discount Program under Section 1860D-14A, subsection G. The fourth is a payment made by a principal to an agent as compensation for the services of the agent under a personal services and management contract that meets the requirements of Section 1001 federal code that they can go down a rabbit hole and look at. Again, this is why it's so important to run any contract by an attorney who specializes in this field of law to ensure that that contract does not unintentionally violate it or that it does live within one of these safe harbors. Then a waiver or discount of any coinsurance or copayment by a healthcare program if the waiver or discount is not routinely provided and the waiver or discount is provided in good faith. And the last few are a remuneration as described in certain federal codes. Uh, what this exception is essentially for is federally qualified health centers. That if you are registered as a federally qualified health center and you're serving an underserved population, that there are certain forms of remuneration which are permissible. And then a remuneration made pursuant to an alternative payment model is defined in Section 1833Z3C of the Social Security Act. What this exception is essentially stating is that there are value-based reimbursement models and quality-based reimbursement models out there that would fall under this safe harbor. And then they've added an eighth statutory exception regarding any other payment, remuneration, discount, or reduction as determined by the Attorney General in consultation with the Secretary of Health and Human Services by regulation. So the federal government can promulgate regulations regarding EKRA to further define the exceptions, to further define the different words that aren't already defined in statute. However, despite being passed in 2018, we are currently at the tail end of 2025, and no regulations have been written regarding EKRA yet. And then preemption. In this statute, there is a section on preemption. Under federal law, this section shall not apply to conduct that is prohibited under Section 1128B of the Social Security Act. That's the anti-kickback statute. So if it is illegal under the anti-kickback statute, it don't need to also prove EKRA, essentially what that is saying. And then state law, nothing in this section shall be construed to occupy the field in which any provision of this section operate to the exclusion of state laws on the same subject matter. This again kind of goes back to private insurance was initially was primarily the lane for state government, and state government primarily regulated private insurance. So what this is stating is that there may be state laws, and this does not occupy the field or preempt those state laws. Now, if it is a federal law, and with regards to supremacy clause, states may regulate more strictly, but they cannot outright contradict federal law. And that is EKRA. And now we're going to pivot for a second and talk about the anti-kickback statute. This is the original one. This was passed back back in the 70s, and as you can see on this slide, it's very similar language to EKRA about knowingly and willfully soliciting or receiving any remuneration in exchange for inducing referral. However, it only applies to a federal health care program, which is different than EKRA. EKRA is an all-payer statute, whereas the anti-kickback statute only applies to individuals under a federal health care program. And those three are Medicare, Medicaid, and TRICARE. For those who are not aware, TRICARE is it's the insurance plan for military for veterans. The anti-kickback statute has a much wider scope of exceptions than EKRA. I think there's over 30 different safe harbors and exceptions for the anti-kickback statute. Now, it's not to say that if something is allowed under the anti-kickback statute but prohibited under EKRA, it is okay. And I'll get to that in a second. As stated before, it's much older, so it's passed in 1972, which means it has had significantly more opportunities for judicial interpretation and precedent regarding regarding how it applies to certain programs. And then because it's had so many more appearances in federal court, courts lean on anti-kickback statute precedent when reviewing EKRA claims, essentially to fill gaps in judicial opinions. Now, how to contrast that, the two together. As stated, EKRA is an all-payer statute versus the anti-kickback statute, which is a only for federal health care programs. What is covered under EKRA, only referrals to or use of a recovery home, clinical treatment facility, or lab are the only things that are covered by EKRA. Under anti-kickback, any person involved in item/service is reimbursable by a federal program. It's much more broad than EKRA. And then exceptions. As mentioned before, there's fewer different statutory exceptions for EKRA, specifically the 7 statutory exceptions and the 8th, which allows for the promulgation of regulations, but the regulations that have not been written yet. And then under anti-kickback, there are many statutory exemptions, exceptions, and safe harbors. If an arrangement fits a safe harbor, the anti-kickback statute, the risk of liability is significantly lower than if it doesn't fit into one of those safe harbors. And as mentioned before, there's over 30 different statutory and Office of Inspector General referenced safe harbors for anti-kickback. Those we will not get into today because that could be a whole hour seminar in itself. Now, issues for compliance with EKRA from a recovery housing standpoint, also from a treatment provider standpoint, to be honest. Firstly, vague terms that are not defined in statute. Refer. What does it actually mean to refer an individual to a recovery home or a treatment provider or a laboratory? Inducement. This year, so the Sheena case that was mentioned earlier, that is from this year. That was the first appearance of EKRA in a federal appeals court in the Ninth Circuit across the country. For the Ninth Circuit, is the first time that EKRA was set in front of that court, and they were the first ones to define induce, and this mention of undue influence requirement, that that sent a lot of attorneys kind of scratching their heads on whether that should be a requirement, or if you just take the statutory plain language and say knowfully and willfully uh, engage in this action where you know what you've done is likely to influence the decision, regardless of having undue influence, if that should be sufficient. So there will most likely be further opinions on this matter as more of these cases make it to federal court. And then indirectly and directly, as mentioned before, they're broadly interpreted. So like, what does it mean? How many degrees of separation does it take before someone is no longer subject to this liability? Lack of opportunities for federal interpretation. As I was just saying, this year is the first year that a federal appeals court has had a chance to review and opine on EKRA, and unfortunately, they only looked at a few pieces. So hopefully, there's more and more chances, we'll get better guidance on what this looks like. Lack of federal regulations. It's very difficult to comply with a law that requires you to wait for federal lawsuits to take place for you to have an interpretation of it. That's supposed to be the purpose of the regulations, is to go into much more deeper language regarding the law itself, so that individuals know exactly what they're getting into and how to be in compliance. I'm sure many of you who have compliance officers have scratched their heads about EKRA and anti-kickback on whether or not what they're doing is in violation, or if it's an acceptance of it. Conflicts with anti-kickback exceptions. A specific conflict with regards to employee safe harbors. So in the anti-kickback statute, there are specific safe harbors regarding employment agreements and personal service contracts that may be based on a per referral or amount billed payment plan. However, that would be prohibited under EKRA. So you have two conflicting exceptions there. And then may conflict with state laws that regulate private insurance, with private insurance initially being and historically being under the purview of state governments. It is very likely that states have enacted laws regarding the regulation of private insurance that may conflict with EKRA. And then both anti-kickback statute and EKRA are criminal offenses, which means that there's no private right of action. You or I could not go sue a clinical provider or recovery housing operator and claim anti-kickback statute or EKRA. They're criminal offenses that have to be brought by the government. Now, how does this apply to you guys? How does EKRA and anti-kickback apply to recovery housing? Like, while recovery housing itself is not generally covered by a private or federally funded healthcare programs, services offered by community partners can be. Lab testing, I'm sure many of you engage different labs in confirmatory testing regarding toxicology. Clinical providers, individuals who are providing PHP, IOP, outpatient, or individual therapy, and then primary care. And then, of course, primary care would have to not be associated with an actual hospital itself. And both EKRA and anti-kickback make it a crime to pay or receive anything of value for steering people to particular recovery homes, treatment programs, or labs when a healthcare plan, when a health plan is paying. So regardless of recovery housing itself not being a reimbursable service, if they are on the receiving end of remuneration for impacting what it should be an independent decision of an individual seeking treatment, they may be found liable for violation of these criminal statutes. And then here are some examples, more recent examples of interactions between the federal government or cases involving the federal government and recovery housing operators. In 2023, a recovery housing operator in Charlotte was sentenced to 30 months in prison for running a scheme in which she recruited Medicaid eligible individuals into her housing, forced them to undergo medically unnecessary drug tests, and sent those tests to a co-conspirator lab that paid her kickbacks from the Medicaid reimbursements. Now, memory serves, this was over $32 million of fraudulent testing that they hit her with. Now, if you notice, these dates are not very far apart, but just literally 3 weeks ago, 4 weeks ago, this same housing operator in Lexington, Kentucky, in our state, has pleaded guilty to a kickback conspiracy involving payments made from a drug testing laboratory in exchange for referring residents. Residents were Medicaid recipients. In this situation, the housing operation was called Serenity Keepers. It was based out of Lexington and Louisville. And this individual, Dolores Jordan, was accepting $5,000 biweekly payments or solicited kickbacks of $5,000 every 2 weeks from a lab company that her family had an interest in to send upwards of $23 million worth of fraudulent tests during a three-year period. But yeah, they've come down on her hard. There has not been a sentencing in that case yet, but it is a solid example of when recovery housing and labs mix with kickbacks. And then two other settlements which have been fairly recent. In 2024 in Massachusetts, First Psychiatric Planners, DBA, Bournewood Health Systems, agreed to pay between 5.5 and 6.5 million to settle Department of Justice allegations under the False Claims Act. The government claimed that Bournewood offered free sober housing to patients in order to induce them to attend its partial hospitalization program. Now, as you can see, both of these examples, and I'll talk about the Minnesota one in a second, but are about False Claims Act. In 2011, the anti-kickback statute was amended to create a presumption where anytime there was a kickback, any claims that resulted from that kickback would be considered false claims. And the False Claims Act, that is a civil charge versus the kickback charge. And civil charges require a lower burden of proof. They only require preponderance of the evidence versus criminal liability like or EKRA, which is beyond a reasonable doubt. Additionally, there is a private right of action to False Claims Act. Um, and researching for this presentation, there was actually an example that came up of a $78 million suit where an individual sued a clinical provider over their fraudulent building under the False Claims Act. Now, how that works is first the government has to have a shot. And that specific $78 million example, the government took 4 years to respond back to this individual and say, we will not take the case, which then she went and did it herself. And then was able to actually go after that clinical provider for initially kickbacks and then false claims. Now, the second example here is a very recent one from earlier this year. In 2025, in Minnesota, the New Way Alliance settled with Department of Justice and agreed to pay $18.5 million to resolve alleged violations of the False Claims Act. A component of the charges was New Way inducing Medicaid recipients to receive services from New Way for IOP, other clinical services as well. The government alleged that this inducement took the form of free recovery housing. Now, and this will show you the disconnect between around EKRA is this organization was actually given awards by the state government for the services that they were providing. Uh, Yet the federal government has come in and found them in violation. So there is a ton of misinformation out there, and there's a lack of understanding, even among huge organizations, uh, around what is the right way and wrong way to go about this. Now, how can you, as a recovery housing operator, mitigate your risk? Ensure that freedom of choice is honored. Federal regulations around Medicaid state that beneficiaries may obtain services from any qualified Medicaid provider that undertakes to provide the services to them. Um, there may be an argument made specifically around IOP housing, that freedom of choice may be satisfied by going to a certain house that has an integrated provider. That's something that will need to be determined in court. That's not something that can be determined by you or I. However, mitigating risk from a recovery housing operator standpoint is ensure that an individual is not losing their housing because they want to receive services from a specific provider that is unrelated to the recovery residents. Review individual state laws that may mirror or occupy the field of EKRA or anti-kickback statute. There may be a potential for stricter prohibitions. I know here in Kentucky, we have a mirroring statute to the anti-kickback statute. However, we do not have a mirroring statute to EKRA. It is a mirror. It is not a more stricter statute. However, there may be states out there that have stricter prohibitions regarding what is or what is not a kickback, or what is or what is not a prohibited relationship. And then reviewing any contracts or arrangements and memorandums of understanding with labs or clinical providers, with counsel specializing in healthcare regulations. And I can't emphasize that enough about counsel specializing in healthcare regulations. Attorneys are like doctors. They have specialties on what a field of law that they practice on a day in and day out, the research that they're doing, the case law that they know in and out, is generally relegated to very specific fields. Healthcare regulations are very, very complicated. Ensure that if you're reaching out to counsel, that this is what they advertise that they do. They specialize in healthcare regulations, or it's one of the fields of law they specialize in. Train your staff. Train staff on recognizing body brokering or kickback arrangements so that if they receive a phone call, or even if, say, they're at a meeting and someone talks about a situation, they're able to talk with that person and help refer them elsewhere. Now, when to hit pause and call counsel. So here are situations that may come up that as a recovery housing operator should stop in your tracks. Tell the individual that you're working with, like, let's run this by an attorney and ensure that this is okay. A lab or a treatment program or marketer offers to pay you. I'm sorry if anyone can hear. We have four dogs and they all started howling in the basement. I'm not quite sure why. uh, let's see. Someone proposes a per bed, per admission, or per test payment arrangement. Whenever there's something that the payment amounts change based on number of referrals or a percentage of billing or anything, that's something that should be run by an attorney. A partner wants residents to use a specific provider or lab as a condition of free housing or services. That could be a violation of freedom of choice. That is something that should be run by an attorney. You are unsure whether a discount, stipend, or scholarship could be seen as remuneration for referrals or for using services covered by a health plan. So any uh, we've seen a couple instances out here in Kentucky where clinical providers will reach out to recovery housing operators and lease one of their houses for housing. Like that's a situation where run it by an attorney and ensure that there's nothing within that agreement or the way it's being operated that may be in violation of this. And then, and I was happy I was able to get a nose icon for this. If it doesn't pass the smell test as too good to be true, an example I have of this is I'm actually trying to assist a recovery housing operator right now, based in Kentucky, where her and her husband were hired, quote unquote, hired by a clinical provider. They were recovery housing operators. They were hired and given executive positions or executive titles within the organization and promised six-figure salaries for their work, but they were never given job descriptions. They weren't actually doing any of this work, but they came to us and kind of complained that that the clinical provider was no longer giving them their percentage of the billing and that wasn't paying them their $125,000 salaries for jobs they weren't doing. So if it doesn't pass a smell test, reach out to an attorney. It's probably too good to be true. Uh, key take Key takeaways from this training. Uh, you as recovery housing operators, you control the roof over someone's head. Individuals in recovery are a vulnerable population. Uh, that type of relationship almost creates a presumption of a risk of inducement to steer their decisions. And I mean, I can tell you my personal experience as an individual in recovery who entered a recovery residence is, I was ready to do whatever the operator said was the best thing for me. However, that while that removed my agency, uh, fortunately, the one I went to had my best interest at heart. Also, wasn't trying to steer me to specific providers, but me coming in with nothing and me needing their help, I was automatically at risk for undue influence. Second takeaway is EKRA is an all-payer statute, while the anti-kickback statute is focused on federally funded programs. Now, one point of note here is while the anti-kickback statute is focused on Medicaid, Medicare, TRICARE, federally funded programs, federally qualified health plans, like if you're getting something through the marketplace, that those are not covered by the anti-kickback statute. Those would still be considered private plans such that EKRA would apply. Department of Justice is actively pursuing schemes where free housing or mandatory testing is used to drive billable services. And I think this is a very important takeaway to recognize uh, which federal laws are, I don't want to say enforced, but prioritized is the better word to use, changes based on what administration is in office. Not even just what party, but what administration. And what we've seen is a shift from the previous administration, emphasis placed in fair housing and discrimination suits, to this new administration does not seem to have as much emphasis on that. However, there's a much greater emphasis on fraud, waste, and abuse. Um, I was just reading a news article about a federal task force which is being sent to Massachusetts to assist in their fraud and abuse program. So, Department of Justice is actively looking at how Medicaid is being abused and how different insurance programs are being abused and what sort of fraud is out there. I know here in Kentucky, we have newly established this year a Medicaid Oversight Advisory Board, which just listened to a presentation yesterday about specific reimbursement codes that were being abused around outpatient services, which were heavily used by individuals in intensive outpatient programming in IOP and PHP and OP. And then the fourth takeaway is the safest path is to honor resident choice, avoid any payments or perks tied to referrals or testing, and use flat, fair market value contracts for legitimate services. Does it pass the smell test? Is it something that uh, looks like this resident has their freedom of choice with regards to choice of a clinical provider? Um, does it seem like we are steering them in a certain direction? Are we financially compensated for that steering? And then, as always, when in doubt, contact a lawyer. And that concludes my presentation. And I wanted to leave some time for questions. Um, while I can't give outright legal advice, I am not licensed to practice law. I'm not licensed to practice law in the state of Washington. I am happy to answer any questions that I can. I know this was quite a dry presentation, so sorry if everyone fell asleep. So you have a hand raised from Adam Orozco.
I have a question. For example, in a situation pertaining to drug court, so we have a drug nonprofit treatment center who has a contract with drug court, and as such, they are demanding or determining or um, on which house a person lives in. So if someone's in drug court, they have to go to this particular nonprofit for IOP services. And then that nonprofit says you need to live in a specific recovery house. And we'll tell them, no, you can't live in a different house. You can't have any choice. You're going to go where we send you, or you're in violation of drug court, and you go back to prison.
Are you asking if that is a permissible
how would that fit
scenario?
into everything we're talking about here? Because it seems like it violates the voice and choice, and it also it's just like a monopoly on the money that's being passed around by the state.
Yeah, so there may be with court orders to specific modalities or clinical providers. That's outside of my realm of expertise when it comes to whether or not that violates patient freedom of choice. So I cannot speak to that.
Yeah, yeah. They do have to go to that place for IOP. I'm speaking more of the treatment center than demanding which residential recovery housing that the person lives in while they're in their IOP.
And again, that's something that how that arrangement is set up would have to be run by an attorney, whether or not the specific verbiage of that contract or memorandum of understanding is permissible or not. I'm sure there's a litany of scenarios where it would not be permissible, and then there's a ton of scenarios where it would be perfectly fine.
Okay, okay. Thank you.
No problem. Thank you for your question.
I don't want to hog the time, but I do have one more question. If
Sure.
In the event that say an IOP, behavioral health agency providing intensive outpatient treatment, establishes their own residential recovery housing and then self-refers, under the promise of free housing. Uh, with that, and in that situation where clients are basically forced into participating in additional type treatments that they may or may not really even need, billing the state to cover the rental, the price of the beds. Does that play into any of the scenarios that you were speaking of earlier?
So that's a very good question. And it is something that all 50 states are currently trying to determine what does colloquially we call it the Florida model. Um, uh, IOP or housing recovery housing with an integrated IOP that the residents are required to attend as a condition of residency. Um, there is a lot of questions about that on what is the right way to go about that. uh, there's an argument that could be made that freedom of choice is satisfied by prior to me entering the recovery residence, I've gone over a resident agreement that states that I will be attending services there. Uh, that there's an argument that has not been settled in court, so that's not a judicial opinion. However, there's another argument that says that, well, once that person is in and they have a problem with that therapist, now Medicaid does not pay rent. I know, and I can speak specifically in Kentucky. Medicaid does not pay rent. Medicaid is fee for service, and recovery housing is not one of those services. So it doesn't cover anything related to, does not cover anything related to recovery housing, despite what many news articles put out there about recovery housing being funded by Medicaid. They are in fact wrong about that. Um, when it comes if an individual is in that type of residence and then is no longer in clinical services but they lose their housing, is that a problem? Personally, I think yes, it would be a problem because now, I talked about earlier about undue influence, and as a recovery housing operator, there's an influence you have over someone's room and board, where is it impacting their freedom to choose their clinical provider based on they may lose their housing if they don't get along with this therapist, or the example that I try to give is someone afraid to tell their therapist something because they're afraid they're going to lose their housing because of how integrated everything is with dual relationships. It is a situation that is going to need to be either opined on judicially, where someone will need to file a lawsuit, or the Department of Justice will need to file a lawsuit, and this will need to be determined at a judicial level in front of a judge to see whether or not it is or not permissible. Or another option is at the federal level, there may be directives given or advice given to the individual state agencies and licensure branches around the country on what is an appropriate licensure for this style of housing, this style of treatment. So there's a lot of different routes that may take. Unfortunately, that there is not a solid um, like I can't give you a solid answer on that question just because it hasn't been fully fleshed out yet.
Thank you.
You're welcome. That is a good question, though, and it was a major topic of the NAR conference this past year, or this year, in October, was recovery housing with integrated clinical services and what that should look like, or is that permissible? Does that impact the social model of recovery? How can it be done properly? What is the right way to identify what is a NAR level 4 type C recovery residence? There are a lot of questions out there regarding this more prevalent style of housing and how it is impacted by EKRA and the anti-kickback statutes. The
I
best,
attended a conference there this year.
yeah,
The
wonderful.
One of the things that were in that whole scenario is what happened is clients are being brought in, and they're basically being forced into MRT under the guise of, well, we're going to give you free housing. And then they force them into MRT, bill the state for additional services, and then turn around and use that to compensate themselves for the beds. So it's just kind of like it almost appears to be a criminal enterprise that's just going around and around in circles, billing the state. But thank you.
No, no problem. And one of our providers sent me a letter they got from one of the managed care organizations, like one of the Medicaid providers, about this issue, and it was a notification to everyone that reimbursement for outpatient services is not to be used to directly or indirectly cover the cost of housing. So I thought that was very interesting to come from a managed care organization. But that is not something that, how that is determined is extremely difficult to really ascertain exactly what is happening in each organization.
Thank you.
See, any further questions? I know this is a very, it's a very difficult topic to really talk about, and something that is, I mean, it's very confusing to go through and try to see like where does recovery housing lie in this? What is an appropriate relationship? I know me as a housing operator, the outside of the residents' well-being, the number one priority is how do I keep the lights on? And everyone on this call is going to know that no one comes into recovery housing on a winning streak. Very few people come in with money. I mean, if you're on a winning streak, what are you doing going to a sober living house? I know I personally didn't come in with any money. And so you're making an investment in these people, and a third of the time, at 15% of the time, they leave owing a ton of money. And so trying to fill those funding gaps, uh, relationships like these seem very tantalizing. They seem like great ideas, and people could get themselves in hot water without truly understanding the nature of the beast when it comes to the Eliminating Kickbacks and Recovery Act and the anti-kickback statutes. No, there aren't any questions. Anyone want to share some good news they've gotten, maybe? Hey, Brianna.
Well, if there isn't any further question or comments that anyone likes to share, you're more than welcome to reach out to us at Walker, and we can help try to answer any questions that you may have that comes of this. But this will be recorded if you want to share it with others who you think will benefit from it. And I got some really good information out of it. Thank you so much, Dane.
Oh, real quick, Brianna.
Yeah.
You said it's recorded. How do we get that recording so we can rewatch it and also share it with some of our
Sure.
house and stuff?
Yeah, so usually in about a week we'll have it on our Walker recordings page, and then we
Okay.
also have a YouTube channel as well.
Oh,
But
perfect.
anyone who is on today, I have your emails, and I send a follow-up email with it in there as well. So a few different ways. Yeah.
Thank you.
Yeah, you're welcome. All right. Well, with that, thank you so much, Dane. Really appreciate you, your wealth of knowledge, and everyone enjoy their day.
Thank you very much. Thank you, everyone.
Thank you.
Yes, thank you. Appreciate it.